Okay, that means we're moving on to our next presentation, which involves our very own past president Kyle Schicchetti, our Governor Abel, and President-elect Dan Clark. I think everybody's here. I hope. I'm going to guess that amongst the three of you, you figured out how you're going to do this presentation. Maybe I don't know.
Yeah, I'll start off. I spoke with Governor Abel and former Governor Clark. And I say former governor. Our presentation topic here is the structures work group. And you'll recall that in 2019, we talked a little bit about it earlier today, that representatives of the Board of Governors were appointed to represent the Board of Governors on that work group, and Governor Clark and I were appointed. Governor Abel at the time was not a governor, but also served in a different capacity on the same work group. And so when we were putting these agendas together, I thought it would be good to have at least a short time to discuss that process, clarify some issues that we all thought that needed to be clarified, and maybe comment on what we should look at again in light of recent developments, what perhaps we don't need to look at again, and what might be more helpful this time. And that's not to say that the structures work group wasn't a very good work group, and I think did its job well and did it very well, led by Chief Justice Fairhurst at the time. But at least my feeling, and I think also President-elect Clark's, was that there was a little bit we could have done better at the end, I think, in terms of processing, digesting, and coming to conclusions. And so I'll talk about that in a minute. Having talked to President-elect Clark, I know he had a few thoughts that he shared with me in an email, and a couple of things that I think we should emphasize. There are differences between this group, the ETHOS group, and the bar structure work group, several differences. One, the Board of Governors is undertaking this work on its own. That's much different than what we had with the 2019 bar structure work group. And President-elect Clark wanted me to highlight that process was intended to be super collaborative. We had 11 representatives, 3 from the Board of Governors, 3 sections, 1 from a small section, 1 from a medium section, 1 from a large section. And then we had 3 Supreme Court board delegates and 2 members of the public who were non-attorneys on the 11-person work group. We also had a very diverse board or task force with diverging viewpoints. We had a federal bankruptcy judge. We had now Judge Andrea Jarman. We had past President Mark Johnson, and then the 3 of us that I'd mentioned. And it was a very good collaborative process, in my opinion. Many of the things that we have on our agenda for the coming months were part of our original analysis. Some of the things, in my opinion, were more important than others. I found the Nebraska situation, how they transitioned their bar, fascinating. We didn't hear from other states, some other states, which I think will also be very informative for us. California, perhaps Texas, other states, their experiences, what they found good about it, what they found bad about it. We heard a little bit about that from several of the presenters. Well, in my perspective, and I'll ask Governor Abel and President-elect Clark, they can share their experiences too. But from my perspective, one of the things that I think, well, there were 2 things that we could have done better then. We could have made more time available for public comment, for sections. And although I think we did a very, very good job of public outreach, there was a lengthy list of folks that the work group reached out to and wanted to make sure that they were included. I think we should do that. In fact, we could even replicate that same list and reach out to all of the same entities that we reached out to before and make sure that they're included and they know about these meetings and can participate. Can also take advantage of our new technology and Zoom, which we didn't have back then. We did have conference calls, but those didn't work all so well. Really, you had to come and participate in person. And now we have the technology to do more than that, which is wonderful for this group. We just need to reach out to them, make sure that they understand what we're doing, why we're doing it, and how they can participate and be involved. We're gonna these meetings will include 2 full days of time for people to come in, present, share their own experiences, viewpoints, and what is important to them in a bar association structure. I think that's great. We'll also be striving to include at every meeting public comment. But we didn't have those 2 meetings in the structures work group. And there was a feeling among some, perhaps not all, I have not talked to all of the former members of the work group, but some that maybe we could have benefited from more time at the end, deliberative time, to talk about what we had learned, how it fit into what we thought was important for the structure of the organization, and ultimately the decision that we made to retain the Integrated Bar Association. And there was a dissenting opinion. I guess it's a dissenting and alternative opinion. And Governor Abel was a part of that. He can talk about that too. That's a possibility for us as well. If we have 2 different opinions that we want to issue and have the court consider, that may be a thing that we want to think about. So those are my initial thoughts. And again, a part of this half an hour that we had arranged for this, I thought maybe it would be good to reserve for questions. If anybody had any questions for at least the 3 of us about that work group. And then any other comments that Governor Abel and President-elect Clark would like to share.
Mr. President, this is Hunter. Are you on mute, sir?
I'm not on mute. I was trying to see if Governor Clark was going to.
Oh, sorry.
Clark was going to speak up, but.
I'm good, Brian. Thank you so much.
Okay, thanks. All right, Governor Bell, did you have some comments you wanted to make?
I do. Thank you, Mr. President, and I will be brief. I just wanted to offer a few thoughts that largely echo past President Schichetti's. I do think the bar structure work group that I had the pleasure of serving on was a good process. It was very collaborative. Much from my observation, much of what we will be doing with ETHOS parallels the analysis, not perfectly, but in large part, the work done by the bar structure work group. And to a certain extent, I think that's fine. We're a different organization engaging in this analysis. There are certainly pluses and minuses to that approach. One thing I would just lay out is that with the bar structure work group, I know the Chief Justice took particular pains to hear from both members and the public at every meeting, and their comments and feedback were very helpful to that organization's work. I also want to echo past President Schettti's comments about the inclusiveness of the bar structure work group. There was a deliberate effort to solicit feedback and participation by dozens of organizations and entities, and that included folks from prosecutor offices, defense offices, legal aid organizations, tribes, minority bar associations, county bar associations, representatives from the Attorney General's office, representatives from the U.S. Attorney's offices. So there was a very deliberate and broad-based inclusive effort to solicit feedback. One other thing that I would lay out is I would encourage us as we move forward to engage in this broad-based discussion that I think we all want to have, but ultimately be fairly disciplined in responding to the three questions posed by the Chief Justice. And the reason I say that is because I share the concerns that were articulated before, that we may have kind of had to rush at the end with the bar structure work group. And here's why. These issues are interesting. There are lots of rabbit holes that we can go down and explore. And if we don't exercise discipline in our analysis, then we could be in a situation where ultimately we kind of get overwhelmed with the various options in front of us, and we don't provide the time that is necessary to engage in a robust analysis of the three questions that are provided for us, and ultimately come down with some strong recommendations for the court that are supported by analysis. So for example, I think one of the things that we will certainly be looking at is the question of whether we retain the integrated model or adopt some sort of an agency model. I assume that will involve very robust discussion, but even if we decide to retain our integrated model, we may want to discuss some variations on that. So one of the things that we did in the bar structure work group was at the very end, with not a lot of notice, not a lot of discussion, we made a recommendation regarding adding public members to the Board of Governors. If that's something we want to do here, I would encourage us to talk about that early and often. I think, one of the interesting discussions we had earlier in the year with the Board of Governors down in Oregon was their experience with the House of Delegates. If we want to do something like that, I think we should discuss that early and often. So I think there are a number of different things that we could consider as far as revisions to our structure, even if we retained an integrated model. And all these questions, I think, go to the third piece, or rather the third question that the Chief Justice has posed to us of, what would we like our ideal structure to be? And I hope that we will be discussing that throughout this process, and not kind of a hurried fashion at the very end. So thank you, Mr. President. Those are my comments at this time.
Anybody have any questions for our three former members of the, there's a hand up. Governor Purser.
Right, thank you. And this is to all three of you, Hunter, Kyle, and Dan. Looking at the letter that was sent by the Supreme Court back to Tara and to the Board of Governors on September 2019, after the recommendation was made, this I didn't see this until the packet came out. This was a close call within the Supremes, 5-4 vote. And so, if you know what was really the issue or issues that the four dissenting justices had with respect to the idea of staying with the integrated bar, that's one question. And then secondly, I guess, is since we have the makeup of the court is different now by at least, I think only one justice involved, any ideas or insight as to what might be the position at this point in time? And I guess in an aside, I guess to this is when you have the Chief Justice is the chair of the board, I think that in and of itself, I think creates a bit of a conflict because you have a heavyweight in there that may or may not engender the most frank discussions. I'm kind of curious about that aspect as well. So it's a three-headed question. So anybody that wants to take those, and I'm looking at Kyle first. So since he's closest,
I'll start if Governor or President-elect want to add on. I appreciate that. That letter is September of 2019. Is that
right? It's right after the report and recommendations were sent.
So I haven't looked at that letter since 2.5 years ago, so
You can look at it, it was close.
Yeah, well, my recollection was that it was close only because of the way that they voted. They chopped up there were several different recommendations, and the way that it was presented, I think, had some effect on what the vote was. I can't tell you or pretend even to know what was beyond the thought, the thinking process of the Chief Justice and the other justices. I do know that some of the discussion at the structures work group, as Governor Abel said, had to do with things that came out of the governance report from 2016, 2014, 15 era.
All of those years.
Yeah, that we talked about earlier, and some of the recommendations that were made from the governance report. And I know that the justices had different feelings about what those recommendations were and how they should have been, if they should have been implemented. So I wouldn't read too much into the 5-4 or 5, whatever the vote was. It's my recollection that it had more to do with the particular issues, because they weren't the same voting on the same issues. They differed for each chunk of recommendations. And I could go back and refresh my recollection on what those were. But sitting here now off the top of my head, I think that was somewhat of the basis for how we got there. But if Governor Abel and President-elect Clark has a better recollection of that than I do, by all means.
Governor Bell, did you want to say something?
Yes, thank you, Mr. President. I certainly wouldn't say a better recollection at all, because it has been a little while. But to Brett, your points, I think the takeaway we can take from that letter is a couple of things. One, there does appear to be an appetite on the court, at least among some members, to look at a different structure. You know, how many members of that of the court that would apply to now, I don't know. But at least at that time, that seemed to be a feeling among certain members of the court. The other piece, of course, is the language in the letter that says the vote was to accept the recommendations of the bar structure work group and keep the current structure for now. I thought that was interesting language, and it indicated the court was going to be continuing to watch this association and what we do, and was certainly open to a different decision in the future. And I think it is telling that they have now asked us for our opinion at this time, which is not too far down the road. So those are some of my immediate thoughts. Oh, and one other point to your question, Brett, I think you hit the nail on the head when you said, you know, there was a heavyweight in the room with regard to the chairmanship of the bar structure work group with Chief Justice Fairhurst. And she did a fantastic job of chairing the bar structure work group. She went out of her way to emphasize that her role was to facilitate and collaborate the discussion. She encouraged frank, open conversation. I think that certainly happened. That certainly happened there. So I don't think there was any sort of inhibition in the discussion and the debate. I know she took active efforts to ensure that robust discussion occurred.
If I might ask a follow-up.
Yes, please.
Yeah, thank you to both Kyle and Hunter. I guess a follow-up question is not just for the three of you, but for the group. Understanding that Chief Justice Gonzalez has tasked us with this process and fully understand it, but would it not make some sense to get from the Supremes areas of interest that they have, so that we can kind of focus on those particular questions, as opposed to just shooting in the dark? And I do that for a couple of reasons. One is that there's a lot of things that are just unknown right now. I think the Supreme Court's term ends in June, and so these cases are not going to be heard this year. And so I'm not sure that there's this urgency to make a decision now, when in fact we don't know if what's going to happen with these cases. Crow is back is right now. It's just there's no decision there. It's something that is just sitting there for purpose of a decision to become. So we have no idea what's going to happen there and whether or not that gets to the Supreme Court level at any point in time. So it seems, in my thinking, that if we could get some direction from the Supremes as to areas of interest or concern that they have, as opposed to this global overview that we have as the Board of Governors, that, in my mind, might be of some benefit, so that we can get some idea of what it is that they're concerned with, particularly seeing what the count was before, and hearing from both from Kyle and Hunter that there were more issues than just whether or not it should be an integrated bar. It just seems that they're ultimately going to make the decision of what it is that's going to happen. And it seems like we get more information as opposed to less information would be helpful, because that gives us the ability to reach out to the community at large and all stakeholders in this matter to get some better ideas of what they're concerned with. It just seems like the more information we have, the better off we are. We are absolutely guessing at what might happen in these Supreme Court cases. I mean, nobody knows. I mean, the court's going to change its makeup by the time that they have these decisions are rendered. So that's my thoughts. I'm curious, but I guess from anybody's standpoint, if that's something that's advisable or not advisable, we just charge on with what we're trying to do at this point.
So let me read in from the chat that President-elect Clark wrote. He says, I think former Chief Justice Fairhurst ran an outstanding meeting and wasn't heavy-handed at all. I think she didn't really tell her hand as far as which way she supported. 2, I agree it's impossible to try to speculate why the court had at the time a 5-4 decision on the report. 3, I think the public member on the Board of Governors issue and House Bill 1788 had a view of the actions of the BOG at the time by some of the court may have led to the 5-4 decision with then court members. But again, it's all speculation. It's a much different court makeup now through 2019. And one of the things that President-elect Clark says first about not telling her hand, I do remember that Chief Justice Fairhurst went out of her way to tell us that she did not want to influence the work group in any way, coming from the Chief Justice or from the court. And I also recall when Chief Justice Gonzalez came and spoke to us at our board meeting, he made it clear that one choice could be a choice to wait and see what happens with the Supreme Court. But he also said we might want to have a plan in place in case that happens and you wouldn't have to scramble. But he was leaving that completely up to us. And I also remember him saying that he didn't want the court. The court could do this if they wanted to. They've gotten their own legal advice, but they didn't want to sway our work and predetermine how we were going to come out. I would think that the court would be apprehensive about giving us more information about what we should be looking at, given that they want to be hands off. But I may be wrong.
Another follow-up question? No, you done? Okay. I think this is Governor Stevens who's got phone number 690.
Can you hear me?
I can hear.
Can you hear?
Yep.
Okay, great. Thank you. And I just wanted to weigh in. And I don't know if we're going to have to keep going down this path, but I strongly disagree with Governor Pertzer. I don't think we have to go back and ask again. I think we've got our marching orders, and here's where I come out. And this is what I said at the front end of this. Actually, a few years ago, when the first structures group was put together, I was of the opinion that don't change the structure, not know how, not no way, not no time. I have shifted that position. And in fact, some of the conversation or the presentation from Julie warms me even more to take a look at possibilities. And, I think the value of this day's session is also for new governors who weren't here when that first group came together. And we have 2 new members of the Supreme Court. But also I do not believe that what we should do is wait for a decision that impacts us and then scramble to figure out what we want to do. I think now is the time, as I think we have voted on a few times more. So I didn't call for a point of order, but I'm just kind of saying I think we need to move forward and not keep going back saying, well, what do you really want us to do? What do you really mean? And do we really need to do this, or ought we really go down this path? I think we're here because we've taken a vote, we've had discussion, and we need to move forward with what I consider a plan for the future, including asking questions. And the last question is a great question as well, which is more in Governor McBride's wheelhouse, which is, even if everything remained the same, should we be looking at a new future, a new approach? So thank you.
Thank you, Governor Stevens. Any other hands up? No, I do have one thing I would like the three participants to maybe talk a little bit about, because they didn't talk about it, but it's in the agenda there listing, is the House Bill 1788 situation that, and maybe answer the question of, do you think that would ever happen again, given these court cases from around the country?
So I would hazard to say that, we, having been the chair of the legislative committee and learned that prior to the time that 1788 had legs, it had been introduced a number of times in the past. And part of the reason we were caught somewhat surprised was because it never had legs in the past and nobody ever thought it would. And to say that we would never see that again in the future, I would say, I would never say that. It's possible that it will come up again. What I found interesting about today's conversation with Chief Ende and General Counsel Shankland was, there was some component of 1788 that resembled moving, not just eliminating the State Bar Act, but moving this toward an agency type model. Because essentially that's what it would have done. It would have moved the Bar Association within the structure of the Supreme Court. So, to say that no, we will never see that again, no, it could come through the legislature, but it could come through the WSBA, and it could come through, other vehicles. So yeah, I think we all should be watching out for something similar, because that's essentially what we're deciding. It's essentially the same options.
How about Governor Abell? You've got your hand up. Any thoughts about that?
I do, yes. Thank you, Mr. President. Just briefly, I think the 1788, the politics are interesting, and the timing is interesting as well. I mean, one of the many reasons that 1788 did not really advance much further beyond it did was the establishment of the bar structure work group, and sort of, I think, the understanding that the court was looking at this issue very carefully, and it really should not be at the forefront of the legislature's mind. Now, ultimately, the bar structure work group came back with very conservative recommendations, and how the legislature may have responded to that, I don't really know, but that was part of the politics around 1788 was, whoa, legislature, you don't take action on it. The bar structure work group is looking at this. So that's one piece. The other piece is that, even if it is the desire of this organization to retain our integrated model and really make, minimal or no changes to it, I believe it is recognized that the Bar Act, as currently on the books, may well need updating, and that I've heard it described as Swiss cheese by a number of informed individuals. So we may well be looking at something that does address the Bar Act, even if we decide to keep what we currently have. Thank you.
Okay, Governor President-elect Clark, would you like to share any information about your thoughts and feelings about that former House Bill 1788?
Yeah, I did a written thing, Brian.
Okay, thanks. I'll read it for you. Governor President-elect Clark says, I think it's important to note that if HB 1788 had passed, that it would have in effect dissolved the Board of Governors and democratic representation of membership on the Board of Governors. I think it needs to be mentioned that Kyle Rajiv, that's Rajiv Majumdar, and former Governor Paul Swigel and Alex Stevens, right? Went to Olympia and testified against the bill on behalf of the Board of Governors and the Washington State Bar Association. We were hit flat-footed with it having legs, but it needs to be known that various governors, including myself, Carla Higginson, Kim Hunter, and Brian Tolleson, really opposed this. Really opposed what? Really opposed the bill, right?
Yes.
Okay. Okay, any more thoughts, feelings, or anything like that? Governor Stevens, you have your hand up still, or is that just a hand didn't ever go down? There we go. Okay. Okay, I don't see any other hands up. Any hands? Not seeing anybody. Okay. All right. Well, thanks so much to past President Schicchetti, Governor and President-elect Dan Clark, and Governor Abell for this wonderful information about the former Supreme Court structures work group that was chaired by our former late Chief Justice Mary Fairhurst. Yeah, I went to some of the sessions in person. I came down here in person and sat in on some of them. And my recollection is not only were they telephonically available, but there was a live stream going on too, at least for some of them, so that you could actually watch what was going on if you logged on properly on your computer. So it was very illuminating, and it was a good, robust program over those, I think it was 8 sessions, right? Half day each. So a lot of good information there. All of that stuff in one form or another is still available at the Washington State Bar Association website. And if you really want to get into the details, you can do that there.